Gardner against Nioso. Next case. Mr. Ball.
May it please the Court, I'm William Ball. I represent, along with Rodney Margall, the appellant Martha Gardner. I'd like to reserve 5 minutes for rebuttal, if I may. As the Court knows, this case is here on an appeal from an appealable non-final order compelling arbitration. There are essentially two grounds on which we believe the Court was in error in compelling arbitration. The first is that this agreement and the circumstances under which it was signed do meet the requirements for both procedural and substantive unconscionability. The second ground is that the agreement violates the public policy that's embodied in the Florida Medical Malpractice Statute, and specifically 766-207. On the procedural unconscionability, two judges in this case, Judge Kahn and Judge Davis, are both very familiar with the Weston case because you all were on the panel. And I'd like to talk about Weston and why I believe this case is different from Weston. First of all, Weston makes it very clear that the central question it's not the dispositive question, but probably the most important question, and the question they talk about the most on procedural unconscionability, is whether the agreement was presented on a take-it-or-leave-it basis, or, on the other hand, did the patient have a realistic opportunity to bargain about the arbitration section. The Court specifically said in Weston there was no suggestion, and I think that word was used advisedly, not even a suggestion that the nursing home would not have deleted the arbitration provision if asked. This case is quite different. The arbitration section of the
patient in Gainesville Health never even knew about the arbitration agreement. I think you might argue that it's a step further rather than a step less.
Well,
that arbitration agreement was bound by a legal representative of the ultimate plaintiff.
Right. Which is true in almost all of those nursing home cases, Judge, and the courts seem to basically treat, it's usually a family member. I think it was in Weston, it was the resident's daughter. I think as a matter of practicality, they realize that these elderly nursing home residents aren't going to sit down and negotiate the terms of their admissions to nursing homes. But I wanted to call the Court's attention, as I'm sure the Court's aware from the briefs, this arbitration provision, before it even gets to the substance of what the patient is being asked to agree to, says it is understood by the patient that he or she is not required to use the aforesaid practice or any physician named for general surgery, and that there are numerous other physicians in Northeast Florida who are qualified to do general surgery. Now, the trial court quotes that language in support of its ruling. I would submit it's exactly the opposite, the significance. This provision clearly tells the patient, if you don't like what's coming, which is the arbitration provision, you can go somewhere else. So there is a suggestion, and to use Weston's word or Gainesville's word, there's more than a suggestion that the provision would not have been deleted. There are other differences. In the Gainesville case, the family members sat down with a representative of the nursing home for 15 to 20 minutes and talked about the admission. Here there was no meeting. And I'd like to point out a difference between the nursing home situation and this case, and really doctors' office cases in general. A nursing home admission is a considered decision made by the patient or, in many cases, family members. They may look at nursing homes. It's a long-term commitment. On the side of the nursing home's not faced with a waiting room full of people waiting to be admitted to the nursing home. The nursing home may admit a person a day, a person a week, a person a month. You don't know. There is the opportunity to have a 15 to 20 minute meeting with the representatives. Here, on the procedural conscionability question, I think the court needs to consider if it's going to impose a sort of Weston model on a busy doctor's office, how can that possibly work? A doctor may see 20, 30, 40 patients in a day. What happens if just a couple of them want to sit down and negotiate over an arbitration provision? It isn't going to work. It's not practical. Other differences between
So one of your arguments is obviously that had this patient, even though I noted in the deposition the employee of the doctor's office said she had discussed the arbitration agreement with up to 40 people. But I assume your argument is you want us to almost take judicial notice of the fact the doctor's not going to meet with her, and he's certainly not going to negotiate and say, okay, you know, now that you bring that up, you make a good point, we'll waive arbitration.
I think it's not formal judicial notice, but I think the court can use its knowledge of the way the world works. It's also, again, a nursing home is looking at a patient who may be living there for a couple of years or longer, and maybe the nursing home needs patients. Maybe they're a little low on capacity. There's a realistic possibility that a nursing home, as in the Bland case that's actually cited by the trial court, in the Bland case, the nursing home presented testimony that it was their policy to waive the arbitration provision if asked. That simply is not realistic, that a doctor, if he's got 40 patients lined up to see him, he's going to start waiving on a case-by-case basis. And these patients, and take Mrs. Gardner, while not an emergency patient, this lady has been told that she's got cancer or may very well have cancer. We're going to impose on people in those circumstances. They don't know if there's going to be a waiver till they walk into the doctor's office. It took her a couple of weeks to get the appointment. It took her several weeks more to get her surgery scheduled. So is the solution to tell this lady and this type of patient, go somewhere else? I would
suggest. Did she waive the argument by not asking any questions? As I mentioned, the deposition employee mentioned that other patients did ask about the agreement, and your client did not. So does that mean we can't get to the question of whether it's a take it or leave it approach?
No, I don't think so, because of the section of the agreement that I read.
What if we agree with you on procedural unconscionability?
All right. Let me move on to substantive then.
Please.
And here we get to an interesting definitional question. And the appellee has prominently talked about this monstrously harsh and shocking the judicial conscience standard. But if you read Gainesville-Weston, what it says is, yes, it cites some older cases that say that, and then it says the modern view is whether the arbitration provision is unreasonably favorable to the side wanting the arbitration. And that is a much, much lower standard. And I think this arbitration agreement does meet that. It imposes fairly draconian caps on non-economic damages that are in the arbitration section of 766-207, of 766, which is 766-207, without making the physician admit liability, which is the quid pro quo that's in the statute. So I think it's clearly meets the standard of unreasonably favorable to one side. The patient gets absolutely nothing out of this arbitration agreement. All the patient gets is caps. I don't have a lot of time. Let me talk about the public policy argument and start by saying this. Another reason the you can go elsewhere argument is hollow is that if it becomes the law of Florida, if this court and other appellate courts clearly tell doctors that they can make their patients agree to arbitrate by doing something that's been done in this case, I would submit that the arbitration mechanism in 766, which is under the Echarte case an integral part of the statute, it's designed to encourage settlements. There was a reason for putting it in there. That will be a dead letter, because every doctor in this state, sooner or later, will be making patients who are coming in wondering if they have cancer, needing immediate treatment or prompt treatment, they're going to make them arbitrate. And you might as well forget about 766-207. There's no reason for a doctor to admit liability in order to get arbitration if all he needs to do is stick an agreement under the nose of the patient and have the patient agree to arbitrate. So we believe that the arbitration agreement does violate the public policy embodied in 766 and specifically 766-207. I'll reserve the rest of the time. Thank you.
Mr. Mathis.
May it please the Court, I'm Kelly Mathis of Mathis & Murphy in Jacksonville. With me is Lori Lee, who authored the briefs in this case. You start off, Your Honors, from the basic premise that arbitration agreements are enforceable if the three elements are found. That is, there's a written agreement, it hasn't been waived, and there's an arbitrable issue. At that point, the burden of proof shifts to the other party to establish unconscionability. And that's really the hinge of what this case turns on, is this issue of procedural and substantive unconscionability, the two prongs that are applied. I think that the appellants are leading you down a rabbit path when they focus exclusively on this take it or leave it aspect of determining as being the sole factor of whether or not a contract is procedurally unconscionable. First of all, that's only one factor that the courts look at, but the bigger issue is not whether it's take it or leave it, because a lot of the contracts that we enter into are exactly that. I would dare say that if we walk into Publix and we get a steak out of the meat freezer, we're not going to be able to negotiate with Publix over the price of that steak. The question is whether there is a meaningful opportunity for that person, in this case that patient, to know and understand the terms of what they're agreeing to. Because the other part of an adhesion contract is that the services wouldn't be available anywhere else. In other words, the cases that deal with that issue.
You seem to be arguing that the take it or leave it approach is problematic, and I'm not sure I would disagree with you, because I'm not sure, just for the purpose of academic discussion here today, that I quite understand that aspect of the Gainesville case, and that I agree with you. Lots of entities have contractual agreements that say, in so many words or less, if you don't like this contract, don't sign.
Right. You can go somewhere else.
But isn't that what we said in Gainesville Health?
Well, I don't think so. In Gainesville Health, it was a little bit different. The patient was already there. The patient was already established. It would have been problematic to move that patient somewhere else. And here, this contract merely informs the patient you do have options, you do have choices. And yes, I think you can infer.
Don't you think that paragraph, though, is, to be fair, that paragraph could have a heading that said take it or leave it?
I think you can infer that's one of the possible provisions of that.
I'm not being critical. I think the paragraph is candidly telling the patient, if you don't sign this, you're not going to be treated here.
I think the patient can infer that, and I think the trial court can infer that. But I don't think in the facts of this case that that's an actual issue, because we don't have that situation. We don't have the situation where this patient said, hey, I would like to be treated here, and somebody told them, this is take it or leave it. I think you can infer that, but nobody actually told this patient that this was a take it or leave it situation.
I think the paragraph tells them.
I think they can infer that from the paragraph.
So let's move on, if you would, please. Let's assume that's a take it or leave it paragraph. I appreciate your point that that's not a sole determinative factor. Can you talk about the other factors on procedural unconscionability?
Well, the issue
Notice to be discussed, that kind of thing.
Right. I think the issue is, does the patient have an opportunity to know and understand the terms before signing? Can they read? The argument is, well, we need to explain this to them. Well, that's not in the law. Do they want to impose some type of Miranda rights? You have the right to know that this is an arbitration agreement. You have the right to know that you can consult an attorney. I don't think that's the law. I think if the agreement is there, it is plain. They can read. This was a college educated.
If we agree with you on all other aspects of procedural unconscionability and agree with you that it's not a Miranda warning and, in fact, that when they're given the opportunity to discuss it, as the deposition demonstrated, other patients have done that.
Right.
So on those factors, you would prevail. But there's a take it or leave it paragraph. If that's a take it or leave it paragraph, you have you can talk to us about it. We'll explain it to you. We're going to explain to you that that's a take it or leave it paragraph. I appreciated the deposition testimony that the employee talked to patients and explained to them those are caps and this is so you can avoid the court system. I mean, there's no real argument that the doctor's office wasn't very candid and forthright and thorough. Having said all that, with a take it or leave it paragraph, is that procedural unconscionability in your view?
Not by itself, Judge. Not at all. In fact, it is simply one of the factors. I think it's, in fact, the Gainesville case that said that factor alone is not determinative. That's one of the issues. And when you look at it in the totality of the procedural unconscionability, everything else goes the other way. This is a college-educated woman. She had an ample opportunity to know this was not an emergency situation. I would certainly agree that if this was a situation where this patient came into the emergency room and we shoved one of these in front of their face and said, you may die if you don't sign this, we'd probably have an issue with that. But that's not this case. And in fact, in those cases, the patients don't sign these types of agreements.
And your client is not going to waive arbitration?
Your Honor, actually it's not in the record, but they have a couple of times. The policy is not to do so. But the individual, I think it's also addressed in this deposition, the individual doctor has the last call.
So should we say that an entity has the right, since that's not in the record, and excuse me for touching on it,
sure,
but that a doctor or an entity has the right to have an agreement that tells consumers, if you will, for lack of a better term, we are not going to waive arbitration. If you want this service, if you want this treatment, you will arbitrate your claim under the terms that we provide.
I think you can have a take it or leave it situation so long as those services are otherwise available. In other words, if that was the only pediatric neurologist in Jacksonville, for instance, and that pediatric neurologist says, I'm not going to treat any patients.
That's not really even a determinant factor either, is it really?
Probably not alone, but it certainly would weigh very strongly. That would be a much closer case.
Can you talk about the substantive unconscionability?
Yes, Your Honor. The substantive unconscionability is, and I appreciate their attempt to relax the standard, whether it's unfair, but I don't think that you look at a contract and decide after the fact, is it completely fair one way or the other? As one of the courts said, that would stand contract law on its head. But is it so outrageously or monstrously unfair to shock judicial?
What does the patient get from this agreement?
Well, what the patient gets is arbitration. Public policy favors arbitration. Well, arbitration in itself is a benefit to the patient because arbitrations are typically faster, they're typically cheaper, they're typically streamlined procedures, and one of the whole things behind the Medical Malpractice Act was try to limit complex and expensive, and I know I'm getting into the public policy, which is separate, but to limit these expensive and complex medical malpractice cases.
Have we held the public policy as a separate ground?
This district has not. The fourth DCA? No, I don't believe so.
Should we reject the fourth's reasoning?
I think you should, because in reality it's the same types of factors, the same analysis as substantive unconscionability. In other words, is it shocking? Do they do something that is so contrary to what our public policy is. But the public policy in Florida always has been it favors arbitration. In fact, it favors arbitration in medical malpractice cases.
But your opponent's argument is that in the Medical Malpractice Act, which, as you well know, was the culmination of quite an effort by the legislature, there was a quid pro quo. I'm somewhat quoting their brief now,
Sure.
where they say this is only a quote, but that the consumer, if you will, tell me some more of the benefits of arbitration for the consumer.
From this particular arbitration provision, the patient also has the right to select one of the arbitrators, which is, I think, a benefit. If it's a judge, they don't have to. One of their big arguments against substantive unconscionability is, well, we have to prove liability first before we arbitrate.
Yeah,
but that's no different than a court of law.
So what about the argument in the reply brief to take the case of a person who has $1 million in non-economic damages, who only shows 50% loss of enjoyment of life, I believe is the phrase, and your cap is $250,000 on non-economic damages. The recovery from arbitration is $125,000, or as the appellant put it, 13 cents on the dollar. And for that, the consumer got a faster procedure for which they got to choose one of the arbitrators.
And a cheaper procedure with less outlay, and the opportunity for more cases to be brought, because if it's a cheaper, faster procedure, attorneys are probably going to be more willing to take those cases. Right now, a lot of attorneys in doing medical malpractice simply don't take the case because they know they're going to have to pay $50,000 to $100,000 in out-of-pocket costs to go to a jury trial, have all these expensive exhibits and videos and everything else to prove their case. In arbitration, they don't have those costs because you're usually going to have a panel that is familiar with medical issues. You don't have to start with basic anatomy 101. You can go straight to the meat of the case. But yes, they do give up that right to that same amount of damages. They get more damages for lost wages under this arbitration than they do under the statute. So they get that, but they get a streamlined procedure. I don't think it's fair for them to say there's no quid pro quo at all. They get nothing else out of it, because I think that they do. And then it goes back to,
No limit on economic losses, right?
No limit on economic losses. In fact, our statutory formula tracks that under the statute. So I think that is an indication that it is a fair limitation. But then you go back to, did they have the opportunity to understand it, and did they agree to it? Throughout history, people have been signing limitations of liability. They've been signing contracts that affect their rights. And this court still has the opportunity, under the unconscionability issues, to deal with those situations that are just patently unfair. And I mentioned earlier, the case of the patient coming in the emergency room that has an emergency situation. The patient that has it presented to him buried in the fine print on page 33 out of a 37-page document. You still have those opportunities to say, wait a minute, in this case it's not fair. But to issue some kind of blanket pronouncement that this court should carve out medical cases, medical services, as opposed to the myriad of other services available under the sun, for this super heightened special treatment that we've got to sit down with them, we've got to explain it to them, we've got to make sure that they don't give up anything at all, that we tell them that they've got to have an attorney sitting there present, we tell them that they've got to have a right to an attorney. In the cases where the patient can't read, and I cited in the brief the case of the Edding case where the lady was legally blind, and frankly, gosh, if there was a case kind of close to the line, I would think that would probably be it, but they enforced the arbitration agreement in that case too. But we don't have that in this case. We don't have the emergency situation. We don't have the fine print. We don't have this buried on page 33. we have a college-educated woman who had all the time in the world. Now, there was some dispute as to whether she got this agreement 2 weeks ahead of time or on the day of the appointment, and the trial court did not resolve that dispute, so we don't know how the court, but there was certainly evidence, strong evidence, that she got it 2 weeks ahead of time. So she had those opportunities. And you're right, she didn't ask any questions. It still might be a different case if she would have gone and asked a question and be given the wrong information, be given misleading information, or being told simply, gosh, I don't know what that does at all. But here you've got it very clear in the agreement, arbitration shall be in lieu of and instead of a trial by judge and jury. Now, some folks aren't going to know what in lieu of means, but that's lawyer stuff. But they're going to know instead of a trial by jury, and I think they're going to understand that. And she signed this page directly. So we think that this ruling should be affirmed.
Thank you.
I would submit this is a classic contract of adhesion in the
Let's
existing.
say we agree with you.
Okay.
I know you have limited time, and
Right.
it's procedurally unconscionable because it's a take it or leave it contract.
Right.
But on substantive unconscionability, do they not have a strong argument that you certainly can deviate from the legislative policy? People can waive any right they so choose. You have unlimited economic damages. That's an advantage, right?
It's an advantage if you win the liability issue, that's the huge difference. You can, first of all, it's only that 20% you get. You get 80% under the statute anyway, so they're saying you get 100%, not 80%. But if the person can't prove liability, she gets 0, and that's the big difference between this and the statute. Arguments made that she knew and understood the agreement. Well, she didn't. She testified that she thought it was about how she was supposed to pay, and I would just call the court's attention. No, it's not. The agreement's not buried in a 37-page document, but it's as buried as it could be. And this is interesting, and it's not in the briefs because I didn't think of it till this morning when I was looking at this thing. But this financial agreement, the first page is about insurance, and it ends with a sentence: "I will notify North Florida surgeons immediately upon any change in my insurance." We then, as the second page in a different type font, it seems to me, they have stuck in this arbitration agreement, which they don't even call an arbitration agreement in the document itself. They call it a doctor-patient agreement. And then, so you've got that, and then you go to the third page, which picks up on insurance again. And you can actually read from the first page to the third page, and it flows completely. They stuck this arbitration agreement in the middle of this to make it as hidden as it could be in a relatively short document. As far as the benefits of the statute are concerned, the reason it's not going to, arbitration without an admission of liability isn't really going to gain anybody much, is the difference between arbitration under the statute is you don't have to prove liability. You don't have expert witnesses. We all know the big expense in the med-mal case is expert witnesses. You're going to have the same type of expert witnesses necessary in this sort of arbitration as you would in a trial.
Is the formula, this restrictive formula for general damages, the same as it is in the Medical Malpractice Act? The percentage of capacity?
Yes. Yes, and as I read the Med-Mal Act, the example I think we gave in the reply brief, if you got $1 million of non-economic damages and you've only had one of your arms cut off and it's arguably cost you 50% of your ability to enjoy life, then you get 50% of $250,000. And under this agreement, only if you've already proved liability. This is not, and the arguments I hear is, oh, it's too burdensome to make us tell a patient what the agreement's about and to tell a patient that she has some rights. It's not. The France case really lays out a sort of formula for how you can do this and be fair to the patient. They put their arbitration agreement in a separate document. It was conspicuously called an arbitration agreement. Here we've got the word arbitration, but it's right under the bigger print that repeats the statement, North Florida Surgeons Financial Agreement. That heading's on the arbitration page as well. In France, so they call the attention of the patient to the agreement, in addition to being conspicuous in a separate document. And then they told the patient she could take it home and consult with anybody, including an attorney. And it's interesting, this is a factor that the trial court apparently thought was important, because she mistakenly says that this arbitration agreement tells the patient she can consult with an attorney. It does not tell the patient that. And that's one of the factors that the France court relied on in finding that the agreement was not procedurally unconscionable. Public policy, as to Judge Thomas's question of whether the public policy consideration is proper in this kind of case, I believe that the courts have said that we're going to look at these arbitration agreements like other contracts. And I also believe, without being a contract lawyer, that it is always the argument that a contract violates public policy is always an issue if it legitimately exists. In other words, it's not the exception that makes that an issue in a contract case. It's a normal part of a contract case. We would ask the court to reverse the order compelling arbitration with instructions that the trial court proceed with the case.